Hi folks, welcome to SQE1 window. In our criminal litigation series, we are talking about corroboration, identification, and character at trial in today's session. And we are exploring chapter 7 of our criminal litigation series. So these areas are absolutely critical because they determine what evidence juries hear, what warnings judges must give, and ultimately whether convictions are safe. Each topic involves judicial direction designed to prevent miscarriage of justice. By the end of this session, we will understand when corroboration matters, how Turnbull directions protect against mistaken identification, and how character evidence operates at trial. So all of it is about, evidence. So let's start with corroboration. What exactly is it? Corroboration is independent evidence that supports other evidence in the case. It's used when the original evidence source seems potentially unreliable and we need additional confirmation to strengthen confidence in key facts. The critical word here is independent. Corroboration cannot be mere repetition of the same evidence or evidence from the same source. It must come from somewhere else entirely. So corroboration most commonly arises with accomplice witnesses. People who participated in the crime but now testify against co-defendants. Their motivation to shift blame or minimize their own role makes their evidence potentially unreliable. However, corroboration is not about repeating the same story. It's about independent evidence pointing towards the same conclusion, thereby increasing confidence that the evidence is reliable. So in exam, it can ask define corroboration, number of definitions, but you need to choose from. What you need to choose is independent evidence that supports other evidence when the original source is potentially unreliable. So I hope you will get this definition right once you are sitting in your SQE. So when corroboration is relevant in modern English law, when does corroboration actually matters? There are two main situations. First, very rarely, statute requires corroboration by law for certain offences. These are exceptional. Most offences don't have mandatory corroboration requirements. Historically, there were more, but they have been largely abolished. Second, and far more commonly, judges may give warning about unreliable witnesses, even though corroboration is not legally required. This is discretionary, governed by a case in 1995, that is McInjula-like case. So modern law treats corroboration warnings as largely discretionary rather than mandatory. The judge decides whether a particular witness requires a special warning based on case-specified circumstances. However, discretion is not arbitrary. There must be an evidential basis for unreliability, something concrete suggesting the witness might not be trustworthy. You can't just speculate. So, counsel should discuss potential corroboration warnings with the judge before closing speeches, flagging any witnesses they believe requires a special direction. So, in exam, it can ask two situations where corroboration matters: rare statutory requirement and discretionary warning for unreliable witnesses can be the answer. So, the next thing, McInjula discretionary warning, and that comes from the case of McInjula that transformed corroboration law by removing automatic warning. Let's understand what changed. Before McInjula, certain witness categories triggered automatic corroboration warnings: accomplices, children, and complainants. In sexual offences cases received mandatory warnings regardless of individual circumstances, but McInjula abolished these automatic warnings. Accomplice testimony does not automatically require a warning. The judge exercises discretion based on the particular accomplice circumstances. Similarly, children don't trigger automatic warning. Age alone does not justify special caution. So sexual offences cases also lost automatic warning. Each case is assessed on individual merit rather than assumption about claimant's reliability. So the next thing is judge now decides whether to give a warning, and if so, what wording to use. This direction recognizes that witness within traditionally suspect categories vary enormously in reliability. So appeals succeed only if the judge direction was exercised unreasonably. If no reasonable judge could have reached the same decision, the standard is very high because appellate courts respect trial judges' assessment of witness they have observed. So in exam, they can ask, is a corroboration warning ever automatic? No, after McInjula case, it's not automatic, it is discretionary. So corroboration and legal requirement, what qualifies a proper corroboration? There are 5 key requirements that evidence must satisfy. First, it must be admissible evidence. You cannot corroborate with evidence that's inadmissible. Hearsay, that does not fall within exceptions. So improperly obtained evidence or evidence excluded under section 78 of base like. So second, it must be independent evidence. This is crucial. Evidence cannot corroborate itself. If witness A needs corroboration, witness B merely repeating what witness A said is not corroboration. True independence means a different source. Third, it must support a material issue, fact actually in dispute like. So evidence confirming peripheral like uncontested matter is not helpful. Corroboration. Focus on the disputed fact that matters. Fourth, it can be either direct or circumstantial. Direct evidence is straightforward. Another witness saw the same event. Circumstantial evidence points indirectly towards the same conclusion. Both form work if they meet other requirements. Fifth, it must genuinely strengthen reliability. This means providing real support, not mere repetition. Ask yourself, does this additional evidence actually increase confidence in the original evidence? So in exam, they can ask like 2 core requirements, independence and support for material issue can be the answer. So these are fundamental. Without them, you cannot have proper corroboration. So typical sources for corroboration, let's identify them. Witness evidence is the most obvious source. Another witness independently supports the account given by the potentially unreliable witness. This could also include admission or confession made by the defendant to police or other. So documentary evidence provide powerful corroboration. Documentary evidence include documents, emails, text messages, social media posts, or digital records that align and support the witness accounts, and they strengthen reliability significantly. So physical evidence, real evidence include weapons, exhibits, items found at the scene that support the witness version of event. If a witness says the defendant used a particular weapon and the weapon is recovered matching that description, that's strong corroboration. Scientific evidence encompass like forensic, DNA matches, fingerprint, blood samples, and other technical evidence that independently confirm what the witness testified. Forensic corroboration is particularly powerful because it's subjective. In exam, they can ask you 3 corroboration examples, or they can ask you to choose from a list they have given. So you should just know the list, all of it. So corroboration and other supporting materials. Beyond traditional corroboration, other evidence types can support a witness account, though they are slightly different in character. Lies told by defendant can support the prosecution case. If the defendant is caught in deliberate falsehood about material fact, this may strengthen the prosecution's evidence. So however, lies must be proven to be deliberate. Honest mistakes don't count as a lie. Refusal to provide intimate samples, DNA swabs, blood samples, so allows adverse inferences while not direct corroboration. Refusal might support prosecution, point of view. So inferences from silence operate similarly. If the defendant failed to mention facts when questioned but later relied or relies on them at trial, adverse inferences under Section 34 of the Criminal Justice and Public Order Act may support prosecution evidence. So previous convictions showing propensity can corroborate if bad character evidence is admitted through one of the statutory gateways and shows the defendant has a propensity to commit this type of offense, that supports prosecution evidence. So wider circumstantial evidence, opportunity, motive, access, conduct before or after the offense can provide indirect support, strengthening other evidence. So in exam, it can ask which sport can backfire at trial. So lies, silence, inferences, all of them, they can support prosecution and damage the case of defense. Exam favorite, that is Turnbull warning, and we have talked about it. So it came from Turnbull case from 1977, and understanding this is essential. Turnbull directions are required when three conditions coincide. First, the prosecution case depends wholly or substantially on identification evidence. Identification is decisive without it. The prosecution case, like once identification does not work, prosecution case collapses. Second, the defense alleges honest mistake rather than fabrication. The distinction is critical. The defense says the witness is lying. This never happened. That's fabrication, and Turnbull does not apply like at that point. But if defense says the witness is honestly mistaken, this happened, but I'm not the person they saw, at that point Turnbull triggers. Third, the identification is disputed. If the defendant admits presence or identity is not contested, Turnbull does not apply. When these conditions are met, the judge must give a special warning, both in Crown Court and Magistrate Court. This warning protects against the notorious unreliability of identification with evidence. And this happens to me. I meet someone I never met. They say, I saw you. No, we never met. So, in exam, they can ask what triggers a Turnbull direction. Prosecution depends on identification. Defense alleges honest mistake, and identification is disputed. All three elements must be present for Turnbull warning. So, the next thing we got is to understand special need for caution in Turnbull. So, Turnbull directions follow a structured format. Step 1 is warning the jury about the special need for caution with identification evidence. The judge must warn that even convincing witness may be wrong. Witnesses who seem absolutely certain, who testify with complete confidence, have been proven wrong countless times. Confidence does not equal accuracy. Moreover, mistaken witnesses are often honest. They genuinely believe they are right. This makes them particularly dangerous. They are not lying, so they exhibit none of the signs of dishonesty, yet they are still wrong. So multiple witnesses can share the same mistake. Numbers don't guarantee correctness. So several witnesses might all misidentify the same person, especially if they discussed observation with each other or were exposed to the same suggestive identification procedure. The judge must link this warning to the case facts. This is not abstract theory. Apply these principles to the specific circumstances. In this case, you have heard from 3 witnesses who identify the defendant. Remember that even multiple witnesses can be honestly mistaken. So, in exam, they can ask, why is identification uniquely risky? Because honest, convincing witnesses can be completely wrong, and there is a long history of miscarriage of justice for mistaken identification. That's why it is important. So, very important to understand. Step 2 requires examining the circumstances of observation in detail. The name or the short form that you need to understand is advocate with K. And this helps remember key factors. Though it's not exhaustive, Number one is amount of time. How long was the witness observing the suspect? A fleeting glimpse of 1 second differ vastly from sustained observation over several minutes distance. How far away was the witness from the suspect? Close proximity produces better identification than distant viewing. Visibility. What were the lighting conditions? Bright daylight, artificial lighting, dusk or darkness all affect observation quality dramatically. And O is for obstruction. Were there physical barriers, crowds, vehicles or other impediments between witness and suspect? Known or stranger from K. Had the witness seen the suspect before or was this first time encounter? Prior familiarity generally strengthens identification, though recognition can also be mistaken. A is for any reason to remember. Was there something about the encounter that gave the witness particular reason to pay attention and remember the suspect's appearance? So, time elapsed. How long between the observation and the first formal identification? Memory degrades over time, so delay weakens reliability. Error or material discrepancies. How accurate was the witness' first description, and are there significant inconsistencies between that description and the defendant's actual appearance? An exam question can ask you list 5 observation factors. So keep in mind advocate, time, distance, lighting, prior familiarity, and time gap to identification, all of it. So the next thing is continuing to step 2. Let's focus on timing and description accuracy because these factors are very important. The time gap between observation and identification matters enormously. The longer the delay, the greater the risk that memory has degraded, merged with other experiences, or been influenced by post-event information. The accuracy of the first description is crucial. What did the witness tell police immediately after the incident? Does the description match the defendant? If the initial description differs materially from the defendant's actual appearance, identification reliability is seriously weakened. The judge must highlight material discrepancies. If the witness said the suspect was 6 feet tall, but the defendant is 5'6", like at that point, and that's material. If they said blonde hair, but the defendant is dark haired, that matters. So these discrepancies must be drawn to the jury's attention. Finally, consider whether recall was affected by stress. High stress situations, being threatened, witnessing violence, impair memory from a recall. Stressed witness are less reliable even if they seem certain. So in exam it can ask, why is first description crucial? Because it's the closest to the observation, least influenced by subsequent suggestion, and provide the most reliable baseline for assessing identification accuracy. Because it's criminal law and we need to establish it beyond reasonable doubt. So another thing is recognition evidence, where the witness claims to recognize someone they know, is generally more reliable than identification of stranger. Prior familiarity reduces mistake risk. However, recognition is still, it can be mistaken. So mistakes happen even with close relatives. People have misidentified family members, friends, and colleagues, and it happens with me many times. Recognition reduces risk but does not eliminate it. The jury must still assess quality. Even recognition evidence varies in reliability depending on circumstances, viewing conditions, time elapsed, how well the witness actually knew the person. All of it matters. Don't assume recognition is automatically safe. Research shows that recognition confidence exceeds recognition accuracy. People think they are better at recognition faces than they actually are at that point. People claim it. So in exam they can ask, recognition stronger but not safe, is it? So that's correct. So recognition is generally more reliable than stranger identification. We are still in turn bull. That's what you need to keep in mind. just to signpost you. So step 3 requires assessing identification quality and determining consequences. Let's start with good quality. Good quality typically involves long observation periods under favorable conditions. The witness had ample time, good lighting, close proximity, and no obstruction. These circumstances reduce mistaken identity or mistake risk identity at that point. So if the witness is familiar with the suspect, perhaps recognizing someone they know, this may further strengthen quality, though remember, recognition is not foolproof. When quality is good, the jury can assess the evidence and reach their own conclusion without additional supporting evidence. The identification alone, despite its inherent risk, suffices for the jury to consider. However, even with good quality identification, the special caution warning remains required. The jury must still be warned about the identification risk. Good quality reduces danger but does not eliminate it. In exam, they can ask good quality. So it is good quality. Does sport still matter? Of course, sport helps, but it's not essential. The jury can convict on good quality identification alone if they are sure, but they must still receive the special Turnbull warning in that case. Now consider poor quality identification. This is where Turnbull has real teeth. Poor quality typically involves fleeing glimpses or very poor viewing condition. Perhaps the witness saw the suspect for 1 or 2 seconds in darkness from a distance through obstacles. The risk of mistaken identity is high, unacceptably high. When identification quality is poor, judge must withdraw the case from the jury unless supporting evidence exists. This is mandatory, no discretion. So poor quality identification alone cannot safely support a conviction. The supporting evidence needed does not have to meet the technical definition of corroboration we discussed earlier. So at that point, so it simply needs to be evidence that generally supports the identification and reduces the mistake risk. So if such support exists, forensic evidence, admissions, other witnesses, circumstantial evidence, the case can proceed. Without it, judge must direct an acquittal. So in your exam, it can ask poor quality. What must the judge do? Withdraw the case unless supporting evidence exists. This is a mandatory, safeguard against the unsafe convictions based on weak evidence. So the next step in Turnbull is step 4, and that addresses supporting evidence when identification quality is marginal or poor. The judge must identify what generally constitutes supporting evidence. Not everything the prosecution claims as support, and that actually reduces identification mistake risk. The judge filters true support from false support. The court must warn against false support, evidence that might seem corroborative but actually does not strengthen identification reliability at all. True supporting evidence must reduce the risk of mistaken identification. Ask, does this evidence make it less likely the witness was mistaken? If it simply confirms the offense occurred but say nothing about the defendant's identity, it's not supporting the identification. So avoid circular reasoning. The defendant's presence at the scene does not support identification for the defendant at the scene. That's circular. Look for independent evidence pointing toward the defendant specifically. So in exam, it can ask what counts as genuine support. Evidence that independently reduces the risk that identification was mistaken. Forensic linking the defendant to the scene, admissions, distinctive features mentioned by the witness that match the defendant, all of it. So this is what you need to keep in mind. So rejected alibis, special caution. A common prosecution argument is that the defendant rejected alibi support identification. Turnbull requires special caution here. A rejected alibi is not automatic support for identification. Just because the jury disbelieves the defendant's account of where they were does not mean they were at the crime scene being correctly identified. So fabricated alibis may have innocent reason. Panic is common. Defendants think they need an alibi, so they create one hastily at that point. Confusion about dates, trying to protect others, or simply bad judgment can all lead to false alibis without guilt. So date mistakes are surprisingly common. People generally misremember which day something happened, especially when event occurs weeks or months before trial. A mistaken alibi about Tuesday does not prove the defendant committed a crime on Wednesday. An alibi can support identification only if it's proven to be deliberately and knowingly false. If the defendant generally misremembered or lied for innocent reason, it does not help the prosecution. Most importantly, proving the alibi is false does not prove the defendant was at the crime scene. These are separate questions requiring separate proofs. So in exam, it can ask, when can alibi rejection support identification? Only when proven deliberately false and connected to consciousness of guilt, not honest mistakes or panic-driven fabrications. So when Turnbull does not apply, let's identify situations where Turnbull direction are not required, and that's tested in exam. So even though identification might be involved, vehicle identification cases identifying a car by make, model or registration don't trigger Turnbull. The principles don't apply because vehicle identification differs from personal identification. Long surveillance identification, where officers observe suspects over extended periods, don't require Turnbull. The circumstances eliminate the fleeing glimpse concerns that Turnbull addresses. So cases where no formal identification was made, perhaps the defendant was not picked out at an identification procedure, may not need Turnbull depending on circumstances. Most importantly, when the defense alleges fabrication rather than mistake, Turnbull does not apply. If the defense says this witness is lying, they have invented this identification, that's a credibility challenge, not a mistake. So at that point, mistake risk scenario. So Turnbull does not apply on it. Finally, when the defendant admits being present at the scene, identification is not disputed and Turnbull is unnecessary. In exam, it can ask mistake versus fabrication. Which direction? Answer is mistake triggers Turnbull. Fabrication does not. This distinction appears frequently in exam. Classify the defense allegation correctly. So the next. Now let's turn to character evidence at trial, both good and bad character. Good character evidence may assist the defense. We will explore this through the Y case shortly. Good character can support both credibility and reduce propensity to offend. Bad character evidence comes in through 7 statutory gateways under the Criminal Justice Act 2003. These gateways control admissibility strictly to prevent unfair prejudice. But what is bad character? The statute defines it as evidence of misconduct or a disposition toward misconduct. This is broad. It includes criminal conviction, but extends far beyond. So misconduct encompasses offense. So for example, reprehensible behavior and conduct falling below acceptable standards. It's not limited to criminal conduct. Civil misconduct or simply disreputable behavior can qualify. However, crucially, evidence of facts alleged in the offense being tried is not bad character evidence. The prosecution can present their case about what the defendant allegedly did without needing to justify bad character gateway. So bad character is about other misconduct, not the charged offense itself. In exam, it can ask, what is not bad character evidence? So the answer is evidence of the effects of the offense charged. This exclusion is fundamental. It prevents defendant from blocking the prosecution case by invoking bad character rules. So now let's talk about good character direction. From Y case, the Y case from 1993 established how good character operates at trial. Let's understand the categories and directions. Absolute good character means no criminal record whatsoever, no conviction, no caution, no reprimand, nothing. This is true good character. Effective good character applies when the defendant has old or irrelevant convictions that don't undermine their overall character. Perhaps a minor theft 20 years ago or a motoring offense that does not undermine the character. So judges have direction, they have discretion to treat such defendant as having effective good character. So why requires two potential directions? So why is this a case like that? Get two potential directions. First, the propensity direction. Good character suggests that defendant is less likely to have committed this type of offense. People of good character don't usually commit crimes. So the jury should consider whether this makes guilt less probable at that point. Second, the credibility direction. If the defendant has asserted innocence, typically by testifying, but also potentially through interviews or written statement, good character support their truthfulness. People of good character are more likely to be telling the truth. The credibility directions only applies if the defendant has positively asserted innocence. If they have remained silent throughout, they haven't put credibility in issue. For minor or old convictions, the court exercises discretion about whether to give effective good character direction. This depends on the conviction's nature, age, and relevance to current charge. In question, it can ask propensity versus credibility directions. Propensity relates to likelihood of offending. Credibility relates to truthfulness. Both may apply, but serve different functions. So the next thing is SQE tips, our favorite. First, remember, corroboration warning are discretionary after McInjula's case. Don't say warning are automatic. They are not. Identify the evidential basis of unreliability in your answer. Second, the Turnbull. Work through the 4 steps systematically. Special caution, circumstances of observation, quality assessment, and supporting evidence. Of course, if you miss any of them, you will lose mark, and I wish you don't. Third, understand that proper quality identification means mandatory withdrawal unless support exists. This is not discretionary, it's clear rule protecting against unsafe convictions. Fourth, rejected alibis rarely support identification unless proven deliberately false with conscious of guilt. Don't assume alibi rejection automatically helps the prosecution. Fifth, raise why good character direction early and clearly when representing defendant of good character. Don't let this valuable direction slip through overlooked. 6, for bad character evidence, much of the facts that you need to look at is to just consider appropriate gateway. Section 101 lists 7 gateways with different tests. Know which applies on bad character. So 7th, remember section 101 allows exclusion of bad character admitted under gateway D or G if admission would have such an adverse effect on fairness that is ought not to be admitted. Use this to protect your client. 8th, watch notice and objection deadlines for bad character application. Procedural compliance matters. 9th, non-defendant bad character witness, victim, third parties require section 100 leave with different test from defendant bad character. So I wish you all the best. If you understood our session, if you like it, hit the subscribe button and share it with your friends. It's free. I wish you all the best. Ta-da.